Let's stay with this particular issue and speak to Nthabiseng Dubazana, who's a legal commentator. Nthabiseng, thank you so much for your time this afternoon. The argument for the better part of the morning before we got to the cross-examination was around the dock identification versus the identity parade that should have been held, as the defense argues. Now, the defense is not convinced that, Madlala has pointed the right man, given the fact that, according to them, there were some processes that were skipped here. How much weight does this argument have on both ends?
Well, from the defense perspective, it is very interesting, or rather disappointing, that there was no identification parade that was held. So the process, the way it usually works, would be that once a person has been arrested and there's like multiple people that were involved, as was the case here, then it would mean that the people who were present at the house would have had an opportunity prior to this matter being on the roll for trial to identify the persons who've been arrested as the perpetrators on the day in question. So now we are dealing with a situation whereby there was no identity parade. There's nowhere where the accused persons before the dock were they were pointed out as the people who were in the house who actually committed the crime. And then over and above that, when the state was leading evidence, yesterday, not today, when they were leading evidence, the witness pointed out to the accused without a basis being laid. So in other words, how it usually happens would be, so sir, the people that you were in the house on the day in question, did you see them in the courtroom? The answer would be yes. Can you point them out? And then they would point them to the accused persons in the dock. And that didn't happen. So that is the main gripe that the defense attorneys are having at this moment.
Does that have any impact then going forward to how this particular matter unfolds, or even when the closing arguments are presented? Could we see this coming back again if the court doesn't make a decisive ruling on it?
Definitely. This is the reason why the defense is raising things such as, what were you drinking? What was your intoxication level at? Was it at night? Was there enough light? Was there all of these things? These are factors that we use when we do our closing argument, saying that it is not possible that a person could have seen clearly the way a person looked if these were the circumstances surrounding the attack at the time. Things like how fast did the event happen? How quickly how soon after they entered the house did they attack the deceased, and all of those things. All of those factors are things that we're going to bring out in heads of argument, saying that based on all of this, we submit as the defense that it is not sufficient evidence to prove that the accused persons before the court were the ones that committed the crime, because the people in the house or the witness could not conclusively say that these are the people that actually committed the crime.
I suppose then there will be some difficulty, especially as you talk about the moving parts of this, because even Tobane, for example, pushing that particular point, saying that it was so quick, things were moving in the house, and listening to Madlala yesterday talk about how when the first shot rang out, in fact, he then, quickly ran to the bedroom, which may then cast some aspersions as to who did he see in that particular moment, because things were possibly happening fast.
You hit the nail right on the head. That's exactly what it is. So if the second the first shot happened and you ran to the bedroom, where were the people entering the house? And was it from the kitchen, from the front door? How far is the bedroom from the front door? How quickly did you go into the bedroom? Were you able to even notice anybody who shot the shot? And all of those things. Too many factors are in play here for a person to stand there and be confident enough to say that I did see Nthabiseng come in and I saw her be the one who fired the first shot, when on the other hand, I'm stating that I ran into the bedroom for cover and it was dark and we were drinking and all of these things. So it's going to be very interesting to see how the state is going to cover that aspect.
I suppose then at the same breath, they're going to, try, as they've started now, to poke holes at his credibility. I mean, you look at the fact that they're bringing up statements that he would have then made over the course of time. And he says that there have been so many people that are involved here. So he made these statements. Yes, I'm not the one that wrote the contents, but I signed off, which says that then I'm okay. But, all of these things are pointing towards a credibility issue that they are trying to push towards as well.
Definitely. And the reason that these statements are brought up by the defense, remember, this is what we prepare when we prepare for trial. We use these statements that are provided to us by the state to prepare our clients and our defense and all of those things. Now, when a witness comes into the box and says something completely different to the statement, we now bring the statement as evidence. So what the Nthabiseng did when he was giving, we call it laying basis. So he had to lay basis for the statement to be admitted as evidence into the court. So by virtue of the witness saying that he did not write the statement, he had to confirm that at least he understood the contents of the statement, he knew what was contained in there, and he signed off on it, and it was commissioned. Those four rather steps were there, and as a result, he can now cross-examine him on that. So now already the court will have to decide on the probative value of the contradictions between the statement and the viva voce evidence. But it's already a step in the right direction in poking holes in the story of the witness.
There's a version that, was put to Tumelo this afternoon, and you're looking at the version of what may have happened in the House, an argument ensuing because of, what may have been an argument over the two sisters at the time. Is this a way that Nthabiseng is trying to bring back the other docket into this particular conversation?
I think it is a way of trying to, as we said in the beginning, to poke holes in the story. Because if there was an argument that ensued and this version was either confirmed or denied by the witness, unfortunately, I didn't see that part today. If it was confirmed or denied by the witness, and it brings credibility as an issue. He cannot exactly bring back the docket unless it has officially been disclosed as part of the evidence that's going to be used in this case. Then that way there's no need to actually bring it back in quotes because it's already there. But he is now making sure that when he goes on and brings on these witnesses who are going to confirm what he's saying, what he's putting to the witness, then it shows the lack of truth in the witness's statement, and thereby relinquishing all the accused guilt from them, so that they can be found not guilty, or at least at minimum a 174 is granted on their behalf.
We're running out of time in about 20 seconds. Something happened this morning where we saw Advocate Malisela Defo making his way to court, saying that he's back from leave. A lot of people were confused by that, including his own former instructing attorney. What did you make of that?
I was shocked. I'm thinking, why are you here? You informed the court that you are withdrawing as attorney of record, that Nthabiseng has gone on with the matter, and you're demanding an audience with the judge. Why do you think that will happen? It makes zero sense. So there's no reason for him to have been at court whatsoever.
I get the sneaky suspicion that it's not the last time we've seen him in this particular matter. But thank you so much for your time. Do appreciate it. That was a legal commentator Nthabiseng Dubazana. We were looking at the developments in this trial of murdered goalkeeper Senzo Meyiwa.